Kiiza, Eron, qualifies for admission to bail.
The Uganda Law Society is in horns of dilemma as they analysed Eron Kiiza case of bail application. This follows the recent approval by the High Court in Kampala that granted human rights lawyer Eron Kiiza a cash bail of 20 million shillings. This comes after an appeal against his earlier conviction for contempt of court by the General Court Martial. Eron Kiiza, a prominent advocate for civil liberties, was arrested and convicted for the contempt of court on the January 7th and sentenced to the 9 months in prison.
The Eron case, while it has created some dilemmas, it is largely part of a bigger crisis. What is the crisis then? The crisis that we are facing is a crisis of democracy, it's a crisis of politics, it is a crisis of rule of law, it's a crisis of access to justice, it is a crisis of the judiciary and the legal profession. That's the crisis that we are facing. Specifically, when we look at it as a crisis of our justice system, and of course the key players there are the judicial officers and the members of the bar or practitioners. When we look at this case as part of that crisis, we are looking at the judiciary in a crisis, which is a crisis of rule of law. Justice is in a crisis.
In his address, Mbazira Christopher, an LLM in human rights from the University of Pretoria, and the legal practitioners stated that the lawyer Eron's case justice was delayed and disregards of the human rights.
Blatant disregard of human rights, including by judicial officers. And sadly, this has included disregard of non-derogable rights, because sometimes disregards of human rights may be justified as a part of justifiable limitations, but when it comes to non-derogable rights, the issue is quite different. So including disregard of non-derogable rights, including fair trial, freedom from torture, and the like. For instance, we've seen so many cases, and the other day somebody was making a comment publicly that we've seen instances where, for instance, judicial officers disregard the fact that an accused person is dripping with blood, with wounds of torture and gashes, open gashes on their body. But the judicial officer disregards that and actually continues trying an accused person.
Amos Koko, the advocate in High Court, celebrated the ruling in his speech. He furthermore elaborated on the issue of the bail, which limits most of the Ugandans in accessing justice in High Court.
For the advocates of social justice, equity, and the Human Rights Court, the land justice found that a court did not have jurisdiction to entertain an appeal as it had been filed. As such, that means if you follow formalism, the bail application must have collapsed at that point. For the simple reason, court had found that it did not have jurisdiction to entertain an appeal for want of a law that grants jurisdiction onto a civil court on matters originating from the court martial. And in his wisdom, Justice Elubo, Mike, held that a court of law, that's the conundrum in the Kabazgluka case, cannot grant jurisdiction on another court simply because jurisdiction is a creature of a statute. The proper thing to do